What should you do when you receive a summons? What should you be aware of when you're in court? Welcome to this segment on defendants in criminal litigation. Let us answer your questions. Understanding the summons. After receiving the summons, which parts should you pay particular attention to? First, you should note the contact details of the court and the clerk in charge. Once you're at the courthouse, you'll give your case number to court personnel so they can check on your case. The cause of action refers to the type of criminal litigation on the basis of the facts. The time of arrival indicates the time the proceedings are scheduled to begin. Note the location of the proceedings, including the courtroom number, to avoid going to the wrong place on that day. The branch ID is the branch the court has appointed to hear your case. The type of session reveals what the court is prepared to do on the court date. The most common sessions are preliminary proceedings and trial proceedings. When the case comes to court, the preliminary proceedings will begin, and the court will confirm if the defendant has admitted guilt in the answer to the complaint, and whether they have appealed to investigate the investigation evidence. After the preliminary proceedings have concluded, a date will be chosen for the trial, with cross-examinations and oral arguments, where each side will present their case. The most important thing is that you need to offer up a response or evidence within the stated time frame or appoint a lawyer to defend you. You should attend in person unless you have a valid reason not to. If you receive a summons and don't attend, what will happen? The consequences are very serious. If you don't appear on time without a valid reason, the court will issue a warrant for the police to arrest you, or you'll be listed as wanted by the police. What should I do if I can't attend court on the designated date? If the case involves a non-serious crime, in principle, you can appoint an agent ad litem to attend court for you. If you are unable to attend court due to illness or a business trip, please remember to apply to the court for leave before the court date and attach evidentiary documents. If the court approves, you can then take leave. What if you take issue with anything listed in the complaint mailed to you by the prosecutor? You can submit a written defense to the criminal complaint before the court date or on the same day. Or, on the court date, you can give an oral statement in court. A little reminder: if you need to consult examples of a written criminal defense, you can visit our website, and our AI customer service assistant can help you. Just enter "written defense" in the search box, and you'll find templates and examples to use as a reference. How can I appoint someone to defend me? You can appoint a lawyer to defend you. A statutory agent, a spouse, or a third-degree relative can also independently retain a defense attorney for you. After appointing your defender, you need to sign a power of attorney for criminal action form and submit it to the court. Will the court appoint a public defender or lawyer for me for free? In certain situations, if you have not chosen a defender, the court will appoint one for you. For example, in cases in which the minimum punishment for criminal responsibility is a fixed term imprisonment of not less than 3 years, or in cases of civil strife, treason, obstructing diplomatic relations, Article 7(1) of the National Security Law and its attempted crimes, and crimes specified in items 1 to 3 of Article 8. If defendants are suffering from a mental illness or disorder, or are mentally challenged and are unable to effectively express their opinion, or they're indigenous or from a low-income background, the court will appoint a lawyer for them. Preparing for court. The day you are set to appear in court arrives. If the court has agreed to remote proceedings, please refer to the Remote Court Proceedings Handbook in advance. For more information, you can scan the QR code in the top left corner. The courtroom is a solemn place, so if you do attend in person, please take care to dress appropriately. to show you take your own rights seriously. On that day, remember to bring the summons, your ROC ID card or other identification, and any documents listed on the summons. Ideally, you should register your attendance at the court early, giving yourself time to find the courtroom. Please make use of public transportation when possible. Don't forget to log in a bit early if it's a remote proceeding. There are 2 ways to register your arrival at court: at the counter or the check-in kiosk. After you've registered and arrived at the appointed court, wait for the court attendant to call you in. If it's not your turn yet, you can either stay outside in the waiting area or sit in the public gallery inside your appointed courtroom and listen to the current session. If the appointed time arrives and your case hasn't been called yet, the previous case may have gone over on time. Like hospital clinics, courts hear several cases every day, so please be patient. You can check the progress of the previous case on the court's website or on the LCD monitors outside the court. After entering the courtroom, please remain silent and be respectful. Court procedures and your rights. Taking pictures, video, and making audio recordings in the courtroom is not permitted. If required, you can apply for a CD recording from the court after proceedings are complete. Now I'll take you on a tour of the courtroom. At the front is the judge's bench. Below the judge are the court clerk and the court interpreter. In the center is the witness stand. The victim and the prosecutor are on the right. The defendant and their agent ad litem are on the left. Witnesses and other relevant persons are in the spectator gallery waiting to testify. When called upon, enter the seat designated for the defendant. The judge will check some of your basic information with you, including your name, date of birth, and residential address, and ensure that you are not bound to the will of external parties. Then they will announce the cause of action and inform you of your rights. We advise you to write out a clear answer to the complaint and submit it to the court. When you appear in court, you should address the main points to ensure the court's time is used effectively. The judge will ask you to clarify anything they have questions about. If you're unsure as to your ability to explain clearly, you can provide written documents to supplement your testimony. Please respect the right of others to explain themselves. Do not interrupt them. If you want to counter, please raise your hand. You may speak again with the judge's permission. In court, the clerk will make a written record of the main points of the proceedings. Everyone will have a computer monitor to view this record. If you discover an error or a misunderstanding in this record, you can report it immediately. During a trial, defendants have the right to remain silent. You can choose not to answer when questioned, as you shouldn't be compelled to make statements that don't conform with what you think. In the preliminary proceeding, the prosecutor will explain the facts of the crime, and the judge will explain the details of the complaint and the response. The judge will ask you if you wish to express opinions on the evidence offered up, and the facts as described by the prosecutor. Both you and the prosecutor can ask for additional evidence to be investigated, and the court will define the scope and method for this. The judge will collate this and list the points of contention and agreement between both parties. During the trial process, the prosecutor will explain the cause of action, and you can respond. At this time, both parties will cross-examine relevant witnesses and experts to verify the evidence obtained in the investigation. After the evidence has been investigated, you and the prosecutor will debate your guilt. Then the two sides will discuss sentencing. The judge will ask you to make your final statement. If the verdict has not been handed down by the court yet, the judge will inform the court of the next court date and location. If the judge thinks that the evidence has been sufficiently investigated, he will announce the conclusion of oral arguments. The judge will then choose a date to announce the verdict. If you are found guilty, they will confirm the crime and the sentence. The court will publish the main text of the judgment on the day after it is announced. and you can find it on the Judicial UN's website. Giving testimony in court is not as difficult as you might imagine. So let's uphold justice together.